Alex here with another video on legal nuts and bolts. The topic is going to be subpoenas. For this video, I'm not going to cover why or when to actually have a subpoena issued. I'll cover that in another video though. Right now, I just want to let people know that there are two types of subpoenas, and that when you're representing yourself, you are your own attorney, which means as your own attorney, you have the right to ask for subpoenas. So the two types of subpoenas are the regular subpoena, which just is telling a person you want them to show up at your hearing and testify. And then there's the subpoenas ducas tecum, which allows you to demand just documentation. So for example, you might want to serve like a mental health institution for like psychiatric records or something along those lines. You don't necessarily know who you want to appear and testify until you read the documents. So you can subpoena those documents, and you can have them turned over and then look through them and then find out if there's like a specific psychologist or psychiatrist that you can subpoena and have them appear at the hearing and testify. The way that you get a subpoena in Nevada is unbelievably easy. You don't even need like permission from the judge. Some people think you do, but you don't. I just would go straight to the clerk of the court. Of course, you should go to the courthouse that you actually filed your case in. So if you filed your case in the Second Judicial District Court, then you go to the Second Judicial District Court and you ask that clerk for the subpoenas. The subpoenas will be issued, which means they'll print them out, they'll put a fancy seal on them, they'll stamp them, they'll sign them, and then they'll hand them over to you. Once you have those subpoenas, you fill them out. They have a bunch of blanks on them. You can put like the name of the witness that you want to show up, and you can write what you want them to testify on, or you can explain what documents you want them to turn over if it's a subpoena ducas tecum. I'm going to go into a little bit of detail specific to Nevada, just because I want people to know what to look for in their state. In Nevada, you can't serve the subpoena yourself, and you can't mail it. It can't be mailed. You're going to have to find somebody else over the age of 18 to serve that subpoena on whoever it is you want to testify in your case or turn over documents. You're also going to have to make sure they're provided with a check. So I believe at the moment it's $26 plus 26 cents per mile, but double check on that because that could change frequently. The third thing you're going to have to provide them with is the instructions to the subpoena. The clerk will probably give those to you. I don't see why they wouldn't. Those aren't for you. Those are for you to hand over with a subpoena. Those are for you to have the other person hand over with a subpoena. The other person being a sheriff's deputy, a process server, a friend, anyone over the age of 18. It's not you. Once the subpoena is served, it is binding. If you did everything properly, it's binding. That witness is forced to show up in court and testify. I've never had a witness not show up, and I'm not going to cover what to do in this video when that happens. It's kind of complicated. But maybe I'll cover that another day. My witnesses have always showed up. I subpoenaed a dentist once, a dental hygienist once, stuff like that for my child custody case. And the witnesses did appear, and they did testify on my behalf or in favor of my case. There is one last thing I want to mention in Nevada, and I don't want this to burn anyone else, so hopefully look into this in your state. In Nevada, when your case has closed, so like when you filed your case, there's going to be a process. I mentioned this in my video on hearings. You go to like a case management conference, and then mediation, and then you go to settlement hearing. And then if you haven't figured your case out yet, if you haven't settled yet, the court will open discovery, and then they'll have a trial if you go to trial, and your case will at that point end, and the judge will enter a decree if it's a divorce, or a final judgment if it's a final dispositive order if it's a child custody case. In Nevada, if you try to come back to court after that, which I had to do a bunch of times, if you try to come back to court after that, it's considered a post-judgment motion when you file a motion after your case is closed, after judgment has been entered. And we have an extra rule that imposes extra requirements on us here when we try to reopen discovery on a motion, on a post-judgment motion. So make sure you look into that in your state. It's in Nevada, if I had to subpoena somebody to appear at my hearing, that wasn't really an issue. But if I tried to do a subpoena ducus tecum, for example, I tried to subpoena CPS for some documentation, I had to get permission from the court first to do that because we have that extra rule that prohibits you from conducting certain types of discovery after your case has been closed. It's okay. I mean, I filed a motion asking for permission, and the permission was granted, and so I was able to go ahead and serve that on CPS. But just make sure you look into that in your state so it doesn't backfire on you if you try to get a subpoena ducus tecum issued and served, and your opponent has a savvy attorney, and they're like, "Oh, that's a post-judgment motion. They didn't ask permission," and then it gets denied on you. So just look into that to make sure. So I'm just going to kind of recap now. Two types: subpoena ducus tecum. Where do you get them? Clerk of the court. What do you need to provide with them? Usually it's a check. Usually the instructions need to go with it. And lastly, make sure a person over the age of 18 serves them, not you, and that they're personally served. That you can't mail them or like email them or fax them. They have to be personally handed over. So with that, I will end this video.